All right, good afternoon, everybody, and welcome to today's webinar, Preventing and Defending MSHA Whistleblower Complaints. Today's webinar is the third in the 2019 MSHA Defense Webinar Series presented by Carey, so thank you for joining. As always, we're going to be recording the webinar today, and we will make a copy of that recording and the slides available to you within the next few days. For audio purposes, we're going to keep all participants' phone lines muted, but you can still ask questions or comment by using the chat function in the lower left-hand screen. If there's any questions that you want to ask that you don't want to do publicly or as part of the presentation, please feel free to reach out to me at any point in time. My name is Nick Scala, and I am the presenter for you today. I am the chairperson of the National MSHA Workplace Practice Group at Carey, and I assist companies dealing with MSHA and OSHA matters around the country, but primarily dealing with MSHA investigations, fatality, serious injury investigations, dealing with contest, as well as what we're going to talk about today, 105C claims or discrimination, interference, whistleblower claims. So we're going to take some time today to dig into this relatively deep topic by doing kind of a top-down look. So what is MSHA's role in whistleblower protections? Then we're going to look specifically at that section of the Mine Act, Section 105C, to discuss what the powers are, what complaints might come into that particular jurisdiction, and then we're going to look at how we prove or how MSHA must prove and defend whistleblower claims by looking at the elements that need to be satisfied in order to support a claim. Lastly, we're going to go through some best practices and recommendations on what we should do if we are the subject or a company is the subject of an investigation by MSHA regarding whistleblower or discrimination or interference claims by an employee or an applicant employee. So quite a bit to go through today, and as I said, we are going to be able to answer questions, so if you do have one, please feel free to type it in down in the chat function. I'll try to address it as we go, or table it till the end and we can take any questions that come up. But to get started, let's take a look at the role of MSHA in whistleblower protections. Now, one thing that we can make known as we get started here is this has always been part of the Mine Act since 1977. It was a lesser used function until the last presidential administration, when there was a spike across all industries, not just the Department of Labor, not just MSHA, but very noticeably in those organizations, but across all industries, the government was pursuing whistleblower claims at very, very high levels compared to the past. And part of those, for the MSHA perspective, is two different types of claims. And these are outlined in Section 105C of the Mine Act, and the two claims can be broken down as discrimination and interference. So discrimination, obviously, is we're discriminating against a minor, an applicant minor, or a minor's representative. And those are three distinct groups that are protected by the Mine Act for actions that are considered protected activity. And we'll go through all these separate phrases, such as protected activity, later on as we go. But there's going to be some action that they did, such as participating in an MSHA investigation, or communicating with MSHA, or communicating safety items that they believe needed to address the facility, and then they were discriminated against because of that. The other side is interference claims, and interference claims means that we are interfering with their rights of a minor. So they might not have taken that action yet, but we have done something to make them think that they cannot do a particular action. And maybe that means they cannot contact MSHA to report what they believe to be a safety concern because of repercussions that may come from the company. And that's the case in one of these items that has, or one of these cases that has currently been litigated before the U.S. District Court in D.C. is what actions can be taken by a company to interfere with the rights of a minor. And in that case, a company said that you must contact the company before you contact MSHA, and this is just a very high-level paraphrasing, about a safety defect. And it was found by an ALJ, by the Commission, and it has been since upheld by the D.C. Circuit that that was indeed interference with the ability of those people to exercise their minors' rights, i.e. make a complaint to MSHA. So a little bit different in what those two items can entail and how MSHA must prove them and what aspects go into them. What we have on the screen right now is actually language from Section 105C itself. So this is the part of the Mine Act that gives MSHA the ability to investigate and prosecute operators who they believe have discriminated against or interfered with a minor's rights. So that language says that no person shall discharge or in any manner discriminate against or cause to be discharged or cause discrimination against or otherwise interfere with the exercise of the statutory rights of any minor, representative of minors, or applicant for employment. So several items that we want to look at here is, we're particularly looking at the minor's rights that each person has. And those rights include many things, but this important part for reading this section is that they don't just apply to currently employed persons. They apply to applicants. So someone applying for a job as a minor has that right to work with MSHA or participate with MSHA. And if you discriminate against them because of that, and it can even be for actions they took at another employer that you know about, that can be actionable. Similarly, minors' representatives, those can be, when they are used at a facility, members of the employment, or in rare cases, not members of the employee base at the company, but a union representative is sometimes the common example. And at that point, those individuals are also given the protections of 105C. This does not apply to discrimination based on sex or race or age or religion or anything like that. There are other regulations, obviously, and statutes that apply to that, such as the American Disabilities Act. There are, or other employment statutes. There are also agreements put in place between MSHA and different organizations, such as the National Labor Relations Board, whereas if one of those complaints come into MSHA, they will or should coordinate with the other agency in order to help facilitate that person's complaint in the right direction. Another kind of related section that we're not going to get into a great deal today, but it's another section of the Mine Act, and it's a black lung benefit section. And this prohibits discrimination against coal miners who are suffering from black lung. And there is a separate list of protections there, a separate process, but the main distinction is it does not apply to applicants. That applies specifically to coal miners who are employed and who have black lung from being discriminated against. But for the purposes of today, we're going to focus on what's contained in 105C, which is going to be violations of minors' rights or alleged violations of minors' rights. So we've talked about some protected activity on minors' rights, and in this case, those are almost used interchangeably. And this list is provided by MSHA from a program information bulletin back in 2010. And the reason we're pulling this up from back in 2010 is because there really started to be a concerted effort in pushing forward these protections around this time. And part of that, from MSHA's perspective, was the release of this program information bulletin, which was essentially a notice to the entire industry that this is an area where we can pursue and investigate claims against employers on the behalf of minors, and we intend to do so. And as part of those rights, MSHA specifically listed in this release that the minor has a right to refuse work if the minor has a good faith and reasonable belief that a condition threatens their health or safety. Probably the most common way we get into an employment or discrimination claim is the second one, which is an employee files or makes a complaint with MSHA of a hazardous condition at a facility. And so at this instance, it would be when someone calls and makes an anonymous hazard complaint to the agency, which results in a hazard investigation at your site. If that does occur, they should be anonymous. Oftentimes, though, our workforce is small enough at a mining operation that we can come to an understanding or at least an assumption of who that person is. If you take any adverse action against them, you are likely staring down the barrel of one of these investigations for discrimination. You also have other items in here under minors' rights, which is to testify or assist in any proceedings under the Mine Act. That is because at one point in time, or one part of this regulation, is that you do not want to scare away your employees from working with MSHA if there is a ongoing case regarding contest or conditions at the site. There's also withdrawal from a mine for not having the required health and safety training. So are you providing the requisite training? And this will also stem into, are you performing this training during normal working hours, which is a requirement under Part 46 and 48? Are the employees being paid for their time in training? Are they getting paid at a normal rate? And are they getting coverage for any incidentals or expenses that may be taking place that they don't normally have to cover? So one example for that is if your employee typically has to drive 40 miles to work every day, but for training they for some reason have to go 120 miles, you are supposed to be gauging and compensating for the difference in mileage and any other incidental expenses that come up. Now, some questions have been played out in this in what is our ability to require individuals to get training before they can sit as an applicant. And I think that is an area that we would want to have very thoroughly fleshed out, working with our district to make sure that we are engaging in a proper creation of that kind of plan. But it is nonetheless something that I've been asked about on numerous occasions. And even in that case that you require someone to have training and they go to a third-party trainer on their own in order to get the ability to be an applicant for your company, when hired, you would still have to pay them for all that training that took place prior to employment. So, just an area where there can be some confusion at times, or maybe a gray area, but nonetheless, if we are refusing to accommodate requests that are considered a minor's right, that is going to put us in the position where a minor who is aware of MSHA's ability to investigate these kinds of cases could make a complaint. Now, we as employers are not entirely without defense to this, and there are timelines that need to be followed, and these are not hard timelines in that if MSHA misses them by a day or the employee misses them by a day, it's going to get thrown out. They are typically given a bit of wiggle room on both ends, but one thing that we want to look at is those time frames, because if they are beyond the initial timeline or initial time frame for making the complaint, that is obviously going to be one of our first defenses, even though there may be some room for the person to keep the complaint going. So a whistleblower must make a complaint under 105C within 60 days of the complaint or the adverse action or discriminatory act. This starts to toll the day after the alleged discrimination or interference took place, and that is when we start to count those 60 days. so if someone believes that, or they did some, I guess the way to explain this would be, if on May 1st someone called MSHA, and on June 1st they believe that we discriminated against them because they called MSHA and reported what they thought was a safety defect, starting June 2nd they would be counting down their 60 days to file a complaint. And so that gives you an idea of, it is a long time for them to sit back and think about whether or not we're going to go that route. A lot of times people who know this process do it much quicker. And you will notice that there can be times that employee bases get wind of this as an avenue, and companies or areas of the country go through a spike in these kind of claims. And you want to do everything you can to obviously address any concerns with your workforce promptly and fully in order to avoid that. It is, though, a rather complainant-friendly system at this time, and if someone applies or submits a complaint after those 60 days, they're going to be given the opportunity to explain why they were late, and MSHA still might take on the investigation. So, as I said, it's not a hard stop. Some reasons why a complaint would be accepted after that 60-day deadline is, something along the lines of they didn't know they had the right to file, or even if they knew they had the right to file, they were unaware of the process for which they could file a complaint, or they didn't realize that a discriminatory act was a discriminatory act. And part of that is what we'll talk about later. These adverse actions are rather wide-ranging, and so sometimes they are items that you wouldn't expect. If we're looking, though, at MSHA resources, we already talked about that 2010 Program Information Bulletin, which had a lot of good information in it, and we had some excerpts of that. But also, as with pretty much everything MSHA does, they have a special handbook that assigns procedures through which they should be conducting an investigation. And in the Special Investigation Handbook, there's a section particularly and specifically on discrimination investigations. And part of that is looking at the timelines within. And the timelines, the reason we're going to focus on that for a bit is because these 105C cases, they take precedence in MSHA's eyes. Unless someone is on a fatality or a serious accident investigation, their resources will be allocated to accommodate these 105Cs. I have been involved in 110 cases for agent liability where a special investigator has been called off-site to go and address a 105C and then picked up the 110 when they were done. So these do take some precedence on it, and part of that is these time frames that have been set. So in that, if a complaint is made with MSHA, they will have 15 days to begin the investigation, and they must do that within 15 days. They must also submit all reports internally to TCIO, which is the Technical Compliance and Investigations Office. It's part of the national office in Arlington, within 45 days. And these all start from the date the complaint is made to MSHA. And it doesn't necessarily even have to be to the correct MSHA office. If someone goes and files it at a field office and it's in the wrong district, they will forward it to that proper district and they will give it the credit of the day it was filed. Because again, we're working with that timeline that has to be filed within 60 days of the act occurring. Additionally, we have some other items in there that 60 days after the complaint is filed, the investigation must be completed by MSHA and TCIO and either referred to a solicitor, that's what SOL means, or declined. So to kind of better explain the groups involved in this, we initially have the complaint made to an MSHA office, an MSHA field office, an MSHA district office. At that point, it is the responsibility of that district office, and they will have a special investigator involved. The special investigator, the district management, and the supervisory special investigators will review the case and the findings and refer to TCIO, which is the Technical Compliance and Investigations Office that I just mentioned. It is part of the national office in Arlington. from there, TCIO will make a determination about whether or not the claim has merits, and MSHA will take it further, or whether they will not. And if not, they will decline the matter, and they won't take it up on the employee's behalf. If they do decide that MSHA should take it up, they refer it to the Solicitor of Labor's office. So the Solicitor of Labor is essentially the Department of Labor's attorneys. And MSHA has its own group that look at these type of actions. So it will be referred to one of those MSHA attorneys who will again review the case and determine whether or not MSHA should take the case on behalf of the minor. This decision must be made, if it gets sent to the solicitor's office, within 90 days of the complaint. Now again, these are typically not hard stops on the deadlines, but they try to adhere to them as best as possible to keep things moving quickly in this realm. If MSHA decides that they don't believe there's sufficient basis to move the claims forward for discrimination or interference, the individuals have the ability to do so on their own. And this is called moving forward pro se, or on your own. Even if MSHA doesn't take the case up on behalf of the minor can file their own claim with the Federal Mine Safety and Health Review Commission within 30 days of MSHA's notification about whether or not they're going to take it forward. So a bit of timelines there, but if we look at it, start to finish, there's a claim made, MSHA moves forward with it and sends it to TCIO. TCIO refers it to the solicitor's office, and then say the solicitor's office declines to take it forward. You have 120 days from the date of the complaint till the individual can make a decision to move forward pro se or not. So the reason I bring that up is that's 4 months. It's not a particularly quick process in just normal time looking at it, but for MSHA, it is a very quick process. If anyone's been through a special investigation with the agency or through any kind of accident or serious injury investigation, they move very slow. A lot of bureaucracy, a lot of moving parts, and this is pretty quick for them, although it can seem like an eternity for the company going through it. Now, I will say most times on these claims, MSHA doesn't bump up against these deadlines. They're moving very quick. And part of that is because of temporary reinstatement being an option. And we'll talk about that a bit later, but it is a unique aspect of the 105C process, or the whistleblower process for MSHA, where if the individual requests or on their own, MSHA can request temporary reinstatement either financially or to the actual job position if a person has been terminated or wasn't able to get work because they were an applicant, or if they feel like they have been demoted or decreased in compensation because of it. So there are a lot of moving parts in that regard. So what are we going to look at, though, when we're talking about the elements of the claim? And this is very much more so looking at maybe even an employment question, and how do we establish that as opposed to the MSHA regulations. But this is an employment question when we get into these whistleblower claims. So we need to have several things established in order to support the allegation of a whistleblower claim against a company. The employee must have engaged in protected activity. We must have had employer knowledge or decision-maker knowledge. That person who allegedly discriminated against or interfered with the person's rights must have had knowledge of the protected activity taking place. There must be an adverse action, which means the complainant must have suffered in some way by the action of the employer. And that, again, we've talked about that, but that can be, black and white termination. It can be reassignment to a different shift. We'll go through a whole list of them here in the next couple slides. And then lastly, we have the causal connection. So what this essentially means, you'll also hear later called a but-for test. if not for the protected activity taking place, the employer would not have taken the adverse action against the employee. That has to be established because, again, and that goes back to the knowledge. If we don't know someone called MSHA, but we terminate them for other reasons, how can we make that connection? How can there be discrimination if we did not know that the protected activity even took place? So those are 4 elements of the claim that we have to look at, and each one of those are items, if we're defending against a claim, that we want to try and evaluate very critically to determine if they've been satisfied. So if we're looking at 105C, these protected activities, as I said before, they align very closely with what are described as minors' rights, and that is because the same will ring true for both. So a protected activity, again, is going to be making a workplace safety complaint to MSHA. That is the most common way we get into these allegations of discrimination. Someone will make a claim that, 2 months ago MSHA was on site and I told them about a condition that they then cited the employer, and the employer was mad at me and now they docked my hours. Those are actions that are directly related. That's how we go through that list we just talked about. Participating in an inspection, so talking to the inspector when they're on site, complaining to the employer, participating in an enforcement action, meaning the case, so if MSHA calls someone to testify and they actually go forward. And then again, we talked about the training being another element. So there are a few very specific ones that we see more common than not, and those are what are listed up there. Another one that you often see claimed to be protected activity is participation in safety committees. So if you are having safety committees on your site with your workforce, I have seen in the past that some action is taken against an employee that they consider to be adverse, and they say it's because I was part of the safety committee and I was making safety complaints to the company on a regular basis about the conditions around the site. So we want to make sure that we investigate every complaint that comes in, but you want to be specifically certain in these cases that we're dealing with a potential for 105C, that we're really being careful about what adverse action we take against persons and what there might be in terms of prior contact with the agency. Again, I'm not telling us that we have to be afraid to discipline workers for valid reasons or get rid of workers for valid reasons, but oftentimes, especially with an employee base where a 105C is a known entity or a known quantity, and individuals know about the power of it and the investigation that can take place, we often see some more outlandish claims, and unfortunately then we have to defend more outlandish claims and go through these investigations. We talked also about, as one of the aspects, employer knowledge, and this is what we talked about, that the person who makes a decision that ultimately is going to be alleged to be an adverse condition against the employee did so with knowledge of the protected activity. Now, it can be, like anything with MSHA, a more attenuated definition of knowledge. So an inferred knowledge is sometimes used by the Department of Labor. One thing that is unfortunate on the MSHA side is, regardless of the area, they are pretty lax on providing guidance, written guidance to the industry, especially when you compare them to their sister agency, OSHA, who likes to provide lots of guidance documents, lots of explanations. OSHA is relatively developed in that sense, whereas MSHA has very little. They issue maybe 1 or 2 of these program information bulletins every couple of years, and the same with the program policy letters. These are great areas where we could get some more guidance from them on what they're expecting of us, especially when it comes to whistleblower complaints. But part of that is, this inferred knowledge, and it's a concept that's specifically addressed by OSHA, but it is also in practice accepted and taken into account by MSHA. And, something where that would possibly come into effect is, there's an employee complaint made about an area of the plant where only 1 or 2 employees work. And while you might not have knowledge that it was a particular one of those employees who made the complaint, if maybe you put them both on suspension for a week for other unrelated reasons, they can make the complaint, and MSHA can take a leap that there was some inferred knowledge as to they were the source of the complaint, and therefore this is an adverse action for their protected activity. So again, it gets a bit attenuated, but we know with MSHA it's a strict liability statute, so employers are supposed to know everything that goes on site, and that mentality, while that is not sufficient in these cases to establish that causal connection, they do venture into this inferred knowledge area a bit more often than an employment counsel or an employer attorney would like to see them do, and as much more than the employers would like them to do. But again, it comes back to, from our stance, from protecting against them and defending them, if we don't know that there was a protected activity taking place, how can we take an adverse action against it? And that's where the knowledge comes in. And if we're crafting a defense or if we're dealing with an investigation, those are the items that we want to keep in mind as we go through it. So we've talked a lot about the adverse actions, and we're going to get a bit deeper into that in the next couple of slides. But I think, we probably have a good understanding of what that is. It's a punishment of some kind, or at least something that can be construed as a punishment of some kind. So the standard, and again, this is coming back to more of an employment stance, but employee must show that the action might have dissuaded a reasonable worker from making or supporting a charge of discrimination. So what does that mean? It means that something materially adverse happened to the employee, and it was a result of that protected activity. And a reasonable employee or applicant would have seen it this way. So again, it doesn't necessarily mean that anyone in the most outlandish scenarios would see it as an adverse action, but that a reasonable employee would. So if we're looking at specific examples of what might be considered adverse actions, common ones in the employment realm are discharge, demoting someone, failing to hire or promote, refusing to pay, or a change in duty, denial of benefits, poor evaluations. Those can be claimed to be adverse actions and have found to be in most situations. With MSHA, it gets even maybe a bit more broad, and we have blacklisting. So giving people a negative reference can sometimes be recognized and has been recognized by the Supreme Court as a form of discrimination or interference. Harassment, a hostile work environment, making a threat to prevent someone from doing something. It's also been determined in MSHA courts that denial of overtime, failure to recall after a layoff, suspensions, even paid suspensions, have been determined to be adverse actions, which is, a bit surprising, I think, for some people. A reduction in hours as well. There's also, I've seen allegations, some more successful than others, but that changing a person's piece of equipment that they're assigned to operate can be an adverse action. I think that's probably a relatively hard one to prove unless it's going from a safe machine to an unsafe machine. But nonetheless, employees made a lot of outlandish claims that they were put in an older machine and therefore it was adverse action against them. So quite a long list of what can be considered adverse, and that's again one of the reasons why this is such a complainant-friendly system at the moment, and has been and is designed to be, is because there's this long list of adverse actions that we might not even consider adverse until the moment that it is brought up. The last element we talked about in establishing claims was a causal connection, which means, again, that but-for test. And the employee in this case has to show that if not for them doing the protected activity or taking participation or participating in that protected activity, the adverse action would not have occurred. Again, though, this is one where the agency has taken a more lax stance, and we want to be careful with that because there's much more attenuated situations. Again, I mentioned earlier one of the classes that we've seen a spike in these on is anyone who's disciplined or terminated that was on a safety committee and then makes a complaint just in general that, oh, well, I was on the safety committee, so this is clearly an adverse action for, you know, me participating in that. I think that's attenuated, that's hard to prove, and there has to be some more concrete facts there. But nonetheless, anytime one of these complaints is made to MSHA, it's investigated. So we're now in this process, and as we'll talk about in a couple of slides, the bar for temporary reinstatement is very low, and there's consequences possible there that are both financial as well as more burdensome in terms of the investigation standpoint. We also are looking at, when we're talking about the causal connection, is how close in time was the alleged protected activity to the adverse action. So the longer the time between them, the less likely there's a connection, is what that means. So it's looking at, you know, did someone call MSHA with a hazard complaint 3 years ago and then they got fired, and they're saying, well, it was because of this complaint 3 years ago. I think that's unlikely. That's a very big leap in terms of the causal connection, as opposed to someone who says, I called MSHA last week for an investigation, and now this week, for the first time ever, I'm getting docked a week of pay, or I'm getting put on unpaid leave for something that's never been an issue at the site. Those are the kinds of things that they look at. How close in time was the alleged protected activity taking place to the adverse action? That is taken in consideration during the investigation process. So even if the employee can claim to MSHA, and MSHA believes they found facts to satisfy that all these different elements were satisfied, the complaint can still fail if the employer can show legitimate non-discriminatory reasons for the adverse action, meaning we had valid reason to get rid of this person or to discipline this person or something of the like. You know, that is the burden of proof lies on the employee and lies on MSHA if MSHA takes their case, although it often doesn't feel like that in the MSHA world, much because of the temporary reinstatement being a tool that MSHA can use. It often feels like we're trying to prove a negative from the get-go in one of these investigations. So this is another reason, though, why we want to have a really well-established and well-documented discipline program that we universally and uniformly enforce, and in part across our employee base, because having that information available and having that system in place is going to be our really great defense mechanism in the event that one of these comes into play. Now, we've talked a lot about discrimination, and I want to talk just for briefly on interference a bit more, because it's the vaguer of the two. Because with discrimination, there is a discrimination claim. There has to be, you know, like that causal connection we talked about, but more defined. A protected activity took place, and then an adverse action that took place because of the employer's knowledge of it. Interference is vaguer, and in that I mean you are, or the allegation is that the company has interfered with a person's ability to exercise their minor's rights, meaning perhaps you took some action preemptively to stop persons from calling the agency if there's a hazard complaint or a safety hazard on site. And in that, there's been a series of cases that have been brought forward where employers are challenging these interference claims, and MSHA is also pushing these interference claims forward a bit more. And unfortunately, we haven't got a lot of clarity on them. There are two tests floating around from ALJs right now. One is the test that MSHA is pushing forward, that it should be the standard, and that's called the Franks-Hoy, or the McGarry test, and it is a two-factor test that does not take into consideration the intent of the operator to actually interfere with minors' rights. That test includes a couple items, which include a person's actions can be reasonably viewed from the perspective of members of the protected class as tending to interfere with the exercise of protected rights, and the person fails to justify the action with a legitimate, substantial reason, which importance outweighs the harm caused of the exercise of protected rights. What's that mean? It means that a company did something that a employee felt hindered their ability to exercise those rights. Maybe they said that anyone who doesn't feel adequately trained after going through this program is going to have to take a week off without training or without pay to go train at another facility. Maybe they did something like that. Well, no one made a complaint at that point about feeling untrained, but the claim being that this directly cut off those persons' ability or comfort with exercising that right. The other test, which again was also put forward through an ALJ, is a bit more employer-friendly in that it does take into consideration the intent of the operator, meaning the operator has to intend for this action to interfere with or persuade someone against exercising those rights. Unfortunately, that is the test that seems to be less pursued or less accepted with the ALJs at the moment, and the Commission has not accepted or created a test which they are saying this is the test in the agency or in the Commission for establishing interference. Now, there was some hope in a case called McGarry versus Marshall County Coal that went to the D.C. Circuit, that the D.C. Circuit would just kind of take this responsibility away from the Commission and they would outline an interference test. Unfortunately, though, for employers, that was not the case, and the D.C. Circuit also refused to determine whether or not the McGarry or the test was appropriate, or to create their own test for determining interference. So this is an area of law that we're going to have to watch, and that I think there's going to continue to be contests on, just because it is very vague in what's required and what employers need to do. Lastly, on these elements, before we get into some of the more proactive attempts or proactive parts of this, is explaining temporary reinstatement. And that is an important one because it is one of the strongest tools that the agency has in these proceedings, and it is a rather unprecedented tool in the other Department of Labor agencies. And what it means is that if during an investigation it's determined that the complaint was not frivolously brought, and I must say that is a very, very, very low standard, the Department of Labor attorneys shall, that means they're required to request an order from the Commission for temporary reinstatement. This happens almost immediately before the rest of the investigation is even completed. And what it means is that person is either made whole financially, meaning you pay them to not be on site during the investigation, or they get brought back to their original position. So it's a very strong tool. Temporary reinstatement is granted. It will be lasting until the end of the case that if MSHA takes it forward. If MSHA refuses or declines to take forward the case after further investigation, the temporary reinstatement will drop. And it's not available if a minor takes the case forward on their own, only if MSHA takes the case forward on their behalf. So we talked about earlier those timelines for the solicitor's office to determine whether or not they're going to take the case, or TCIO. If they decline to do so and temporary reinstatement's already been granted, it would drop at that point in time. But This is a tool that it's very strong in MSHA's favor. It's very pro-employee because it lasts throughout any hearings or appeals. So, these can go on for years. If we look at that McGarry test, it is a 2006 commission decision, and it just went before the D.C. Circuit. So if they're paying temporary reinstatement on that, they are still paying that person's wages. And that continues to go on. And even if you eventually win at litigation, you are going to never recoup that money. So it's a very, very strong tool, and a lot of other agencies wish they had it, but I don't know if it would ever get past another law, or at least without quite a bit of pushback from industry, because it is such a strong tool. So again, if temporary reinstatement is going to be sought, it is done very quickly, so it has to be done within 7 days, notified to the TCIO, and then you kind of expedite that process. You can have a hearing specifically on the granting of temporary reinstatement, and if there's ever a situation where temporary reinstatement is being brought up, it should go to a hearing before an ALJ, but again, it's a very low standard, so it's oftentimes, much more frequently than not, it is granted. So if we start looking about how we might want to respond to these, and some best practices in doing so, we want to look at what happens if someone calls MSHA or OSHA, but in this case we're talking about MSHA, and makes a complaint, because that is the most common case in which this happens. If the complaining worker, and this can be the complaining worker you're having called MSHA, or it can be the complaining worker as in there's another protected activity taking place, and we know who it is, we want to ensure there's no retaliation against them. If we're not sure who it is, there's no retaliation against the entire workforce, just because we have to be very clear about this. We have to, and we want to immediately conduct our own investigation to talk about determining timeliness of the claim, to collect our documents, to interview employees, and to have our own investigation and findings. We're also going to want to probably, at this point, begin preemptively putting together our own position statement to provide to MSHA during their investigation. So, this includes getting HR involved. It includes getting managers or non-management, anyone involved in the process. We also want to make sure that we review our personnel files and any policies or procedures on that discipline program, and make sure if we have those records, we want to start collecting those as well. We want to look at what our position statement is going to do and what do we want it to say. Well, we want it obviously to put the facts forward in the light most beneficial to us, right? We want to outline where our defenses are and why we think this is being brought frivolously. So we want to give context to the allegation of the charging party. We want to explain maybe what is our view of why they're making this claim. And we also want to do that while looking at relevant case law. We want to tell a good story that gives a start, a middle. We demonstrate that we take these allegations seriously. We begin establishing that trust with the agency, and hopefully we have a good relationship with MSHA beforehand, so that this isn't something we're having to overcome from the beginning. We want to have a good statement of facts that tells us about the company, also tells us about the party that's making the complaint. We want to talk about those who might be involved, as well as any decisions that were made regarding the employee's performance, or any reasons or background for disciplinary action, especially that which might alleviate our concerns here, or that prove this was a justified action taken by us that they are claiming was adverse due to a protected activity. It is the central crux at this point that we get this position going, and maybe we don't turn over a document immediately. That is our position statement, but I recommend at some point in time that a carefully crafted document, because again, you're entering this into the record, so we want to make sure it's very carefully crafted, is provided to MSHA so that our arguments are in black and white. This should also include some legal analysis to show where supporting case law comes in and supports our claims and disrupts the claims of the complainant. That's an essential part of this as well, because we can't just rely on facts all the time. We want to bludgeon the investigation in terms of our support for this is a valid action, a valid and righteous employment action against an individual. And that's going to include letting those solicitors know who are eventually going to be brought in, our actions are supported by case law. They are supported by the law and by the applicable law to this individual and to the Mine Act. So we want to clearly lay out how the charging party or how the complainant has failed to meet their burden of proof. And remember, we talked about that burden and establishing those 4 elements: the protected activity, employer knowledge, adverse action, and then that causal connection between the two. So we want to look at that, and we really want to make a poignant written statement that we can rely on, because it is going to be the first element that is included in that record. But as I said, it is included in that investigation file, so we want to make sure that it's carefully crafted. Supporting documentation is going to be, disciplinary records. If we need to have employment evaluations or affidavits in there from the supervisors, those are things we can include in that time. We also want to, though, be careful with these, because again, especially in the fact that you are providing non-required documents or non-required MSHA documents, you're now putting MSHA on notice that those exist, which can sometimes create a desire for the agency to dig deeper into those areas. So we want to look specifically at those documents that are very strong in supporting our position and showing that our actions were legally valid. So how are we going to be avoiding these claims? Some of the biggest aspects are going to be to make sure everyone has adequate training. And that means our supervisors, our managers, they have to be trained on on what retaliation is, on what adverse consequences or adverse actions might be, and how to manage these employees, and also how to deal with employees who are coming and bringing up complaints. They should know how to respond to these. They should know what kinds of retaliation or what kind of proximity and time they're looking at, and how to make sure that they are, dealing with these items in the proper manner. They also want to be able to communicate effectively with counsel, whether that's internal or external, or with HR in order to explain what is going on here. But the big thing is they need to be trained on what to do in these cases, and also on our discipline program and how to maintain it and how to implement it uniformly. So if there is any kind of adverse action, and this is even before MSHA is called in, we want to have a clear and written description and documentation of all disciplinary action. We want to have a very clear process for decision making in place, and that means it probably has to be a written procedure beforehand. We want to document training on that. It also is important to investigate any complaint of retaliation internally and to keep our own records and reports of those. Now, I'm not saying you turn those over to MSHA immediately without having formal requests for that documentation, but these are key elements that come into play if we're trying to defeat an allegation that we feel is unfounded. We want to look through that documentation and really have a clear picture that we, one, have a uniformly and universally enforced program. Everyone is aware of the requirements in that program, and we have documentation that shows that we continue to implement it. So I think with that, that sums up where we're at on 105Cs today. We're squeaking in right under the hour mark. So I want to thank you for joining us today, and just remind you to make sure you keep checking tabs on the MSHA Defense Report blog. We'll keep having posts on there regarding updated cases and enforcement trends from MSHA. Also, we have 3 more webinars for the rest of the year, the next one coming up in August. It will be a mid-year review of MSHA and also some case decisions that have come out since we now have a full commission again, which is a very exciting development. Then we'll round out the year with an October presentation on responding to document requests, and then also in December looking at requirements of different types of MSHA citations and orders and what burdens those put on the company. So I'm happy to take any questions that there might be. If you want, you can use that chat function in the bottom left question if you haven't, or if you'd rather ask your question directly to me, my contact information is up on the screen, and you're more than welcome to get in touch with me at any point in time outside of the webinars. All right, it doesn't seem like we have any questions coming in right now, but if anyone thinks of something as we move forward, or as they move forward, or they think about the presentation a bit more, please don't hesitate to contact me. And as always, in the next couple of days, any registrants for the program will be getting a copy of the recording and the slides, and those will also be posted on the blog as well. So thank you for your time, and everyone have a great day.